Mr. Apollos. But at that stage, Ms. Smith also told Ms. Hanif that the police must do their work and they must stop looking for Joshlin. The terminology used at the time to Ms. Hanif was not referring to Joshlin by her name, but rather as the child. I mention it here as the next topic I shall deal with is the admission of the statements by Mr. Apollos and Mr. Van Ryn. Because what became apparent in those interviews that Joshlin was not called by her name, but rather die kind, the child. So let's revisit the trial within a trial, and I shall not dwell on it for a long time. And the reason for that will become obvious. Day after the visit by the minister and the prayer meeting was a massive search in this area, where this venue that I didn't know of before we chose the venue became an operation center. Police officials from all over the province, of all detective branches and all the different sections of SAPS, community members, community organizations, interested people were searching the broader area of Saldanha Bay towards Jacobs Bay, the dunes, the beaches. The Navy was involved, and it became a big operation center. What nobody knew was that Captain Lombard and his team was in the field that day, but led by their commanding officer, Brigadier Nana, who took up position at the sea border offices, sitting in the FCS commander's office. They have already decided that they will have to now re-interview the three individuals, being Mr. Apollos, Mr. Van Ryn, and Ms. Smith, on the same basis of all these discrepancies and the red flags that were raised earlier on that I've discussed, plus the conduct of the individuals in the meantime. So after concluding their work on the search, Mr. Apollos, Mr. Van Ryn, Ms. Smith was brought in by different people to the offices of Sea Border Police, where FCS officers are also situated. Interviews were conducted, and various police officers testified as to what had happened, but more particularly Captain Lombard, Sergeant Fortuin, Sergeant Johnston, as it was alleged that undue influence was exerted on Mr. Apollos and Mr. Van Ryn, and they were viciously tortured. Some demonstrations became laughable, to say the least. The indications on the evidence and what was put to the witnesses were totally different. Plus, I was told that what they had admitted to in those statements came from the police, and the police told them what to say. I have no hesitation in finding that the evidence for the defense on that score was so bad that nobody can believe it. No wonder they didn't come and testify again, because the prosecutors wiped the floor with their evidence, to use the colloquial term. On the other hand, there was no reason not to accept the police evidence of the officials that I've mentioned, because over and above the medical examinations and what was told to the doctors by Mr. Apollos and Mr. Van Ryn as to how they sustained certain injuries they had on their body, I was fortunate that a process was followed where these statements were video recorded. It then not only sits with somebody to add on, because you can see what's in front of you. One can see the demeanor of the deponent. One can see the conduct of the police official taking the statement. One can see the scene. It doesn't end there. Let me turn to Mr. Apollos briefly. We took time, sentence by sentence, confirming or not confirming, both by counsel on behalf of Mr. Apollos and myself. And then, of course, as we know, what's confirmed when Ms. Smith is not in the courtroom is recanted when she is. To make it worse, I've been told that was in those statements came from the knowledge of the police. But then Mr. Apollos tells me he made up the story as he was sitting in front of Colonel Pretorius, which prompted me to pose the question where his sudden talents came from. Because there was information in those statements that the police had no knowledge of. Similarly, with Mr. Van Ryn, turned out that, and I've criticized Captain Siekwe about it, that not everything that he said was written down verbatim. If one listens to the audio, on the video, on the recording, it's crystal clear what he said. And a lot of those issues were not challenged. It was claimed that he was asleep, or that when he yawned, his brain was malfunctioning. But when he testified, it was a different story. Then he was wide awake. Initially, He was spun like a top around an axle. Then, when it became apparent that it is impossible, then he was just swinging or rocking like a boat. We asked him to illustrate. It was clearly impossible. Initially, it was unclear what type of pole or pipe or structure was used to spin him around. Then it became a crutch. Not knowing there was a gentleman in court that had a crutch. The least said about it, the better. My finding is that the credibility was so bad, and on the other hand, the state's evidence was of such a nature that I found it to be credible and reliable, and the statements were admitted. Mr. Apollos and Mr. Van Ryn made their statements, but before they departed, that evening or early morning of the 5th now, there was the encounter between Mr. Apollos and Miss Smith. Miss Smith did not give a statement then. She gave a statement at a later stage. That became the warning statement. Both of them at some stage told the police they must ask Miss Smith. When she was told that they said that, she exploded, asking Mr. Apollos how he could do that to her because she loves him. I'm going to deal in a little bit more detail with Mr. Kutsia and Ms. Lombard. But before I turn to them, it's important that one have regard to the so-called warning statement of Ms. Smith, which was handed in as Exhibit QQ. And this is a statement that she wrote in her own hand. If you look at the time that was given there, she returned home at 11:30. She borrowed the money, bought tik, went home, and she was back at Carl and Ziegers' house at 12:30. Then she eventually went home at 16:45, 4:45. Joshlin was not at home. Now contrast that to the previous statement that I've mentioned. The time that she realized that Joshlin was not at home, the latest would have been 5 o'clock. Thereafter, both herself, Mr. Apollos and Mr. Van Ryn, went on their sojourns to get the gas and to go and tik. No concern. That's on the version, insofar as it's a version of Miss Smith. Now let me turn to Mr. Coetzee first. Mr. Coetzee is a single witness as to what had transpired on the August morning of 2023. Ms. Lombard is also a single witness insofar as it relates to what she describes with the white polo. And I'm well aware that the version provided by Mr. Apollos and Mr. Van Ryn as to how Joshlin was delivered differs from hers. So in both their cases, I will have to apply a cautionary rule. I have to find some warranty of reliability for their evidence. When a court considers that, you may also take into account the demeanor of the witness. Mr. Coetzee made a favorable impression in the manner in which he presented his evidence. He has no motive to put himself in this situation and get into the case. At the time when he reported to the Krugers and Van Zyl, he was unaware of the arrest. Where does he get the 20,000 rand from? Because he was never part of any of these other discussions, and it was not out in the public domain either. So, even on the probabilities, would favor his evidence. More importantly, there is nothing to gainsay Mr. Coetzee from the defense. And I shall get to in which instances inferences can be drawn from the silence of a person accused. In this instance, it calls out for an answer, because either he's not only an evangelist but also a prophet, to have known what was going to happen. He says Ms. Smith told him that. It's not challenged. In cross-examination is challenged, but no other evidence. But it's also supported by the circumstantial evidence around this case. Ms. Lombard is a bit different, because not only is he a single witness on the commission of the crime as she describes it, but she's also a participant. So I've got to treat her as a single witness. It's a cautionary rule. I've got to deal with her as a participant. I also have to have regard that she gave different versions as time went on. When Constable Sihobe, she was a constable at the time, spoke to her on the 20th, she gave one version. Then she made a statement to Captain Sawyer, a so-called confession, on the 15th of March. Yes, she implicated herself, but that was not the full disclosure. Then she appears in court as an accused. She's legally represented. In that time, the legal representative also represents Mr. Apollos. She wants to come clean. He withdraws. They appoint a new legal representative for her, Advocate van Tonder, whereafter the discussion takes place. A statement is then prepared after various to and fro and consultations, checked with her legal representative, and that becomes a so-called 204 statement. Further disclosure. So there are those three different statements. Whether they're different versions, that's another issue. Then she comes in court and she has a difficult time. So from the outset, she was not the perfect witness. But does it mean that if she was dishonest at a particular stage, that I should disregard everything she's saying? Because it is trite. The fact that you pronounce a falsity on one aspect doesn't mean that the totality of what you say is false. The test is that one must look at credibility, but also reliability. And where I apply the cautionary rule, there's no hard and fast rule. It becomes a common sense approach. And I said at the outset, I'm not going to quote all the authorities. I was referred to them, I've taken them into account. It's my understanding of how I need to approach it, and I will do that. So the way it should be done, to my mind, is to see whether there are independent corroboration for aspects in her evidence, if not the totality, where I can find that warranty of reliability. I have asked the prosecutors, when they had to prepare the heads of argument, to give me a mind map. Now let me pause to say, when I deal with her evidence and the mind map, it will also answer my decision, particularly insofar as it relates to Ms. Smith on the application for a discharge. Because Mr. Van Ryn's application was stillborn. As just before that, I had admitted his statement, where he implicated himself with admissions. So I will not deal with the reasons for the 174 separately. Let us go there. So in argument, we went through points that I've indicated I was going to draw lines. Of February. That's the talking at the house. There she's corroborated by Mr. Apollos in his statement. So that's the plan. Insofar as the amount of money is concerned, she's corroborated by Mr. Apollos and Mr. Van Rijn. Also corroborated by Mr. Coetzee. As to the argument that ensued on that day, confirmed by Mr. Apollos to Captain Lombard and Ms. Sosa, places her right there. Then, on what happened on the 19th and her presence there, both Mr. Apollos and Mr. Van Rijn, the microwave, and so on. Even that they had to go and collect the money later. The fact that they smoked a quarter mandrax, in the evidence of Captain Colonel Morris, Mr. Van Rijn confirms it in a social media video that was made. The visit to her house on the night of the 19th, where Ayanda got upset. This is confirmed by Gongota and Kobesi, totally separate from her. She made mention of that Joshlin was sold. Miss Smith, she says, spoke to her on the 23rd. There's no counter evidence to that. This whole issue of hers talking about the Sangoma, Mr. Van Rijn was the one that came up with that at another stage. I can point at a number of issues, and it's not exhaustive, because my view is to look at it differently. We referred to the elements and what the state need to prove on the human trafficking charge. The difference between Ms. Lombard and Mr. van Rijn and Mr. Apollos relate to the means. She confirms, they corroborate her on the plan. At least Mr. Apollos corroborate her on the plan. But both Mr. Apollos and van Rijn speaks about the execution of the plan of disposing of Joshlin like a commodity on the 19th. And that was the plan on the 18th, according to her. And we know as a matter of fact that Joshlin went missing. Read all of that in, and then I'm going to turn to all the circumstantial evidence and the conduct of the parties and the fact that no evidence was placed before the court for the defense. So when one analyzes the evidence of Ms. Lombard that was available at the end of the state's case, no credibility findings have been made yet. Were evidence of corroboration, because the statements of Mr. Apollos and Mr. van Rijn were not admissible against Ms. Smith, but they were admissible against themselves. There's evidence on record, and if it corroborates his state's evidence, that implicates Ms. Smith. It can only strengthen the state's case on that evidence. And that was the reason why I refused it, because there was evidence before the court on which a reasonable court could convict. So the following findings are made insofar as the witnesses are concerned. None of the evidence was disputed. They then became proven facts. Insofar as Mr. Coetzee is concerned, I accept his evidence for the reasons I've given, having regard to the cautionary rule as well. Insofar as Ms. Lombard is concerned, I find sufficient corroboration for the reliability of Ms. Lombard from other evidence and the circumstantial evidence. And that is the discussion of the planning for turning Joshlin into a commodity and selling it. It's a matter of fact that she went missing. She indicated that all three, the now accused, were party to this pact with her. She's confirmed in that regard by Mr. Apollos and Mr. van Rijn. They support her evidence in that regard. Over and above that evidence, now read with Mr. Coetzee's evidence, with all the other pieces of the circumstantial evidence at play. And most of them viewed at independently and individually might not seem significant. Because when one evaluates circumstantial evidence, you look at the evidence in totality. And it is so that all these small little pieces on Ms. Swanepoel's example will complete the puzzle. It might also be seen as the little tiles in a mosaic from which you draw inferences. But, as discussed in our cases, reported cases, like the ball of feathers that becomes like a millstone around the neck of somebody, it weighs you down. So let's look at it. The circumstantial evidence. 2018, Joshlin is a baby. Andrews wants to adopt. Build up a relationship between the two families. Parents does not want to agree. Fast forward to the 18th of February the next year. The 18th of February 2024. Mr. Apollos says he was told by Ms. Smith the reason for selling Joshlin was because of Ms. Andrews doesn't want to stop trying to adopt Joshlin. Circumstantial evidence in that regard. So that little vague tile becomes brighter. Turning to Ms. Andrews. Ms. Andrews describes the conduct of Ms. Smith because she knows her. And she tells us how Ms. Smith behaved herself after Joshlin's disappearance. Whilst we're there, let's deal with her conduct. She's inconsistent as to why Joshlin didn't go to school that day. The timeline doesn't make sense. She comes home at 5 or 4:45. On the one version, she was aware that Joshlin was not at home at lunchtime. And why not go and look for the child? Then you do. But you find it more appropriate to go and charge your phone instead of looking for the child. Then you tell everybody the child made you famous. Then you go jive and dance on the 3rd of March. And there are many more. This is not the conduct of somebody that's unaware of what happened to the child. They go and sleep that night. I want to say stepfather and mother. Next evening, sleep like a baby at Kelly Zeger's house. And so it goes on. Similarly, Mr. Apollos, Joshlin was left in his care. Also, inconsistent versions, hiding Mr. Van Ryn away, not mentioning Mr. Van Ryn being there, does not partake in the search. He's been told by Ms. Smith, stort 'n traan, show some emotion. It's uncontested. Why is it necessary? So what I have is that the conduct of particularly Mr. Apollos and Ms. Smith is not that of a concerned parent. And why not? To my mind, the only inference is because you knew. And that supports in itself Miss Lombard and coming from Mr. Apollos as well. It's not the end of the case. Because all of that was before the court that I've just summarized at the end of the state's case. I confirmed with all three the persons. They chose to remain silent. You have a right to remain silent. As the Constitutional Court pointed out in State versus Busak, it's not absolute. There comes a time where the evidence is such that it calls out for an answer. And yes, you may still exercise your right, but it has risks, because the court can draw an inference. And the inference I draw is, why not come and answer? You've heard the evidence. Why not come and tell me they're lying? But your conduct was such from day one, not of the trial, from the 19th of February last year. There's no real interest. You don't go and search. You don't do what common sense asks us to do. So let's turn to the weather on these facts. I can make a factual finding of what happened to Joshlin. Was she delivered to the white polo? Was she delivered to Makalima's house? As from Mr. Apollos and Mr. Van Rijn. Because of the different versions that Miss Lombard gave, I cannot find a warranty of reliability for the white polo. So that's not proof beyond a reasonable doubt on that score, because of the cautionary rule. But is it necessary to find how the means, how Joshlin was delivered? I've already made a finding as to how the law should be interpreted by saying it's not necessary, but it can be inferred, because you have the plan, you have the purpose, you commodify, you hand over, and it's a matter of fact. Does that satisfy the requirements of the charge? So, on the main count, I have already found that on the evidence before me, Joshlin was exchanged. the fact is that her freedom of movement and liberty was inhibited. Now that in itself are the main elements, the act of kidnapping. Kidnapping is mentioned as one of the means in subsection G of section 4.1. But also, the evidence is from all schools. There were payments, or at least the promise of payments. Also, if one looks at the overriding subsection J of the Act, it refers to the purpose that would include all forms of slavery or practices similar to slavery. And the definition section of the Act defines slavery as reducing a person by any means to a state of submitting to the control of another person, as if that person, that other person, were the owner of that person. So by treating a human being, and in this case a child, as a commodity that can be sold, it falls within that definition. I've already commented by looking at what the Act is for kidnapping when I determined whether it falls under the subsection 4.1 contravention. It's clearly that act of depriving Joshlin of her freedom of movement and liberty, to the extent that her whereabouts is still unknown, is unlawful. So that will satisfy the elements of the offense on count 2. Now, before I make a pronouncement, I also have to deal with the indemnity of Ms. Lombard. I have decided not to deal with that application or my determination of it now. It will be clear from what I've said so far that there will be another stage in this case. And one doesn't know what more evidence might be presented at that stage that might influence that decision. Furthermore, in the event that I have doubt on that question after all the evidence in the case has been laid, I might consider wanting to grant Ms. Lombard's legal representative to address me on the issue before final determination is made. But the primary reason is that I foresee a possibility that evidence might still be laid in the next phase of this case that might impact that decision. So for the reasons that I have stated, I'm of the view that the state succeeded in proving the guilt of Mr. Apollos, Mr. Van Rijn, Ms. Smith on the main count in count 1, and on count 2. So the following order is issued. You may remain seated. On count 1, you are guilty of a contravention of section 4.1 of the Act, read with the other legislation on trafficking in persons in relation to Joshlin Smith. On count 2, you are also convicted of kidnapping in relation to that. Can I just ask the public, please just bear with us. I know that's emotional, and I understand the expression of your emotions. Let us complete our process that we need to do for now. Then I'm going to adjourn. Then you can express your emotions as you wish. Are you 69s? Certainly. Mr. Policy must listen.
On the 27th of October 2020, there's a conviction of theft committed on the 22nd of August 2020. The sentence imposed was a fine of 10,000 rand, or 10 months imprisonment, which was wholly suspended for 3 years on condition not again convicted of theft or attempted theft. And there was also a declaration that he is unfit to possess a firearm. My Lord, that is the only conviction against accused number 1.
Mr. Paulus, do you admit the previous conviction? Good. You will be given the form to sign. And I'm not sure whether... Do you have a fingerprint pad here? You can do the fingerprint later, warrant officer. Just leave it there so long. Leave it by you so long.
My Lord, if I may then proceed, Mr. Van Ryn. On the 3rd of October 2014, convicted of 2 counts of robbery, which was committed on the 17th of March 2014. The 2 counts were taken together for purposes of sentence, and 24 months imprisonment, which was wholly suspended for a period of 3 years, on condition that he's not again convicted of robbery or attempted robbery being committed within that period. And there was 12 months correctional supervision imposed, and he was also declared unfit to possess a firearm. The next conviction is on the 17th of January 2016, also for robbery, committed on the 23rd of October 2016, and there the sentence was 2 years imprisonment. And then the next previous conviction is on the 28th of March 2018. That was a contravention of section 4B of Act 140 of 1992, possession or use of drugs, committed on the 26th of March 2018. The fine there was 100 rand or 5 days imprisonment. My Lord, then the next one is on the 9th of December 2020, convicted of housebreaking with the intent to steal and theft, committed on the 4th of October 2020. He was sentenced to 24 months imprisonment. On the 11th of June 2021, released on parole supervision, which was supposed to be until the 8th of December 2022. There was, however, an extra endorsement where he was readmitted. The endorsement date was the 28th of October 2021 to serve the remaining portion of the sentence, 407 days imprisonment due to a violation of the parole supervision conditions. Those are the previous convictions of Mr. van Ryn.
Mr. van Ryn, do you admit to your previous convictions? Thank you. All right. So whilst the administrative tasks are being performed by the constable, we now need to plan. So I'll tell you what my prima facie view is. We should maybe postpone the matter to a holding date, which will be a date, say, not this coming week, the week thereafter in Cape Town. I will deal with it early in the morning. And by that date, we will then determine whether you're going to lead any evidence in aggravation. I suspect so. Whether the defense wants to call any witnesses in mitigation, then we'll know how many witnesses we need to call. I hope nobody's going to ask me for correctional supervision report because it's not applicable. No, I'm talking to the defense already. I'm talking about correctional supervision, but we also don't know whether there are any other assessments to be done. So once we know that, we will have an idea how long it will take to compile everything, but also how long we will need for the sentencing proceedings. And then I would want to come back here, because I think it's as fair that we do it here, but all the prep work we can do whilst we're in Cape Town, it will also give me the opportunity to, I thought I might still have to go to the office in town today. I was supposed to be in Cape Town today, in the office. But I'll see what I can arrange. So that's just my idea. How do you feel about that from the state side?
That sounds good, my Lord. The state does intend to lead some evidence. At least victim impact statements will definitely be prepared. If the defense, if I may just ask, if the defense could perhaps indicate whether they want to apply for probation officers, then we can assist. Thank you, my Lord.
Mr. Harmson.
Obviously, defense on behalf of the accused one would need to consult with him. I am in agreement with the arrangement proposed by your Lordship for a date in Cape Town. We obviously need to consult with the accused one and then take instructions as far as the procedure further.
Will you be able to, next week Friday, will you be able to advise me by next week Friday? In other words, I can postpone the matter till Friday next week, which is the 9th of May. I doubt that I have appeals, but we will have a courtroom available, so I can do it in one of the courtrooms there. That's just for everybody to report back. This is what we want to do, so that we can start planning from there.
It sounds in agreement. I'll be in agreement with that for the 9th, yes, my Lord.
And then we can say we do it at 9 o'clock.
Yes, I'm in agreement, my Lord.
Ms. Nkabai?
Morning, my Lord. I'm Kabai on behalf of Mr. Van Rijn. I would concur or concede with my learned colleague's submissions that the matter be heard on the 9th. I have to consult with my client, and I will, on that day, explain to court what are my instructions.
Mr. Sivnarine, similar? Okay. All right. So what I'm going to do is it's 10 to 1. All right. I'm going to clearly they must be transported to Paulsmoor. It's going to be difficult now if I issue the order now for Paulsmoor. So I'm inclined to do 2 warrants, 2 detention warrants. To authorize both places. In other words, I say at this place and or that place, so that maybe tonight they can be held closer so that they don't have to take the R27 on a Friday in the middle of a long weekend. Otherwise, the police will only reach Paulsmoor when tonight. And they're going to hit the peak hour traffic on their way to Tokai. So I'll hear from warrant if I say Malmesbury, and then during the course of the week they can make arrangements for them to be transferred. Okay. And will it be Langebaan for Ms. Smith for tonight? That'll just it'll just make it easier, because I can foresee problems if it's too late. Also, we're not sure what time they're going to leave from here now to wherever they need to go, because there's a lot of admin to be done. I'm also aware that because we made the arrangements the other day, that their parents might be here. I'm not going to make an order. It's not my place. But often what I do is, if I convict somebody, and if it's possible, I tell the court orderlies, if it's within your powers, I wouldn't have a problem if you at least have their family speak to them before you take them away. Right? But I'm not going to make an order because I don't know what the arrangements are. So the following is going to happen. Mr. Van Rijn, Mr. Apollos, I'm going to do your warrant dual, so it will be Malmesbury, Paulsmoor. Ms. Smith, I'm going to do you Langebaan, Paulsmoor. You will be appearing at the High Court in Cape Town on Friday. All that will happen there is I will be informed how we're going to do the process further. And it will depend on availability of witnesses, reports, and so on. And once I have that and we determine a date, we'll postpone the matter back here for a day or two. It won't take longer than 3 days, I take it, to come and finalize the matter, where I will then have to impose sentence. I want you to give your legal representatives instructions as to what you want to do. Because remember, there is a prescribed sentence of life imprisonment on count 1. Just remember that. So that you don't sit back and it's your choice. But so that I have everything before me. And I know the state is going to argue for life imprisonment. So, just give your instructions. Members of the public, can you just remain calm now? I'm going to adjourn. Then give the police an opportunity to take Mr. Apollos van Rijn and Ms. Smith out of the courtroom to the holding area. And then you can quietly leave, or if you then want to clap and ululate or whatever, that's your business. Right? I'm not going to stop you, but let's give them the opportunity to do their work. And then we leave orderly. Remember, we're a big number of people in this hall. Let's leave orderly, and thank you for coming. The court will adjourn.